Good afternoon, everyone. This is Attorney Elise Gross with the Presser Law Firm. Today we're going to be talking about partnerships. Before we get started, just a few housekeeping details. If you have any questions during the course of the webinar, please send them into info@assetprotectionattorneys.com. We'll do a Q&A at the end. If you're not already on our newsletter or haven't had a preliminary complimentary consultation regarding asset protection or estate planning, we do have those available. And we also do speaking engagements for groups that are interested in hearing about asset protection or estate planning. Several of our attorneys are able to come and speak if there is a group to be spoken to. A little about myself. My name is Elise Gross again, and I am an attorney in South Florida, have been for over 20 years. I specialize in estate planning and asset protection, and we do probate as well. I'm also an adjunct professor over at Florida Atlantic University, where I teach wills and trusts in their paralegal department. Today we're going to be talking about partnerships. And let's just give a little bit of an overview. We'll talk a little bit about asset protection and some basics there. Then we'll talk about exactly what a partnership is. Then we'll break it down into different types of partnerships, as well as how a limited partnership and some other types of limited partnerships are used for asset protection. And then, of course, we'll wrap it up with some questions at the end. First off, what is asset protection? Asset protection is how you legally hold title to property in such a way that it would be out of the reach of future potential creditors. Now, it doesn't really matter, how many assets you have, even what they're worth. It all comes down to, in your own mind, what do you need to protect? So a person who doesn't have a lot of assets might want to protect the $100,000 that they have because that's all they have and it's irreplaceable. If you have millions of dollars, well then obviously protecting all of it would be nice, but if you can only protect some of it, that would be fine too. So it all comes down to, sitting down and having a full analysis with a client to see what assets they do need to protect. But I have to say that there's really no threshold as to whether or not a person should come in and see somebody regarding asset protection. And if you already have that asset protection plan, that's great because it's always a really good starting point. What we find is a lot of our clients who have asset protection plans, whether they were from our firm or another firm, it's always great to review them just to make sure that what they're doing today is what they should be doing. Sometimes plans have to be changed because laws change or assets change. They may need to be tweaked. So just having an existing asset protection plan may or may not be enough. Sometimes you'll walk away and we'll say everything's great, you don't need to do anything. Other times we'll say, we may need to do some modifications. So just like with any, legal documents or legal plan that you have in place, you always want to revisit it from time to time to see if there's any nuances to it that might need to be changed. Over 100 million lawsuits are filed each year, and that number is growing. Anytime you look on the news or any of the those pop-up sites, you're always going to see people are suing, and people sue for things that are actually real, and of course they sue for things that are not real and things that we all consider ridiculous. But the bottom line is that if you're being sued, whether or not there's any merit to the case, you're going to have to hire an attorney. It's going to cost you. It's going to cost you money. It's going to cost you time. So nobody ever wants to be in a position of being sued. So, one of the things that you can do based on asset protection is to put yourself in a position so that if you are sued, that at least they can't collect upon it. Essentially, there's, statistics are 1 in 4 chance you'll be sued in the next year with an average of 5 lawsuits over your lifetime. Obviously, not every, that's based on basic stats. So you may not be a person who is sued, or you may be a person who's sued 10 times. But, the average is, let's say, 5 times over your life. There's a 50% chance of divorce. It's probably higher. The more often you get married, subsequent marriages, the divorce rate's even higher for the second marriage or the third marriage. So can you protect against divorce? There are potentially things that can be done in advance. I wouldn't go and use an asset protection plan just for the sake of potentially getting a divorce. But a well-planned asset protection plan can be helpful in that kind of situation. Liability insurance, firm believer in it, absolutely. You never know when it's going to be helpful. It's a cheap way to sleep at night. The only thing you need to know is that just because you have insurance doesn't mean your claim is going to be covered. If you get sued and it's not covered, it's probably somewhere in the fine print that you didn't read or nobody explained to you. So we believe in insurance. I have plenty myself. You should have it for anything you do, any business that you have, any property that you own, but understand that it doesn't always cover everything. So what you need to do is always have the backup plan. That's what we do here. Your coverage may not be inadequate. Your insurance company could go out of business. That was something we'd never heard of, and then all of a sudden it started happening. The government had to come in and try to fix what it could, but there were insurance companies going out of business. Then what do you do if you have a claim? And then, of course, there are certain things that they don't cover. Even if it doesn't matter how much you want to spend on it, there are certain financial risks that cannot be covered that no insurance company is going to cover. So it's important to have the insurance. Don't neglect having insurance, but don't rely solely upon the insurance. Number 1, always protect yourself before you have a problem. Don't come in when you have a problem, because if you come in when you have a problem, it might be too late to be doing a full plan. Doesn't mean we can't help you. It just means you're going to be pretty limited upon, what your options are. So the best thing to do is to come in before you have any issue. You can start with a basic plan. You don't have to go full throttle on a very complicated plan. You start with a very basic plan at that point, and then as things grow in your life, as things change, we add some firewalls to it and just enhance the plan. But just because you're not ready to go forward on a tremendous plan, that doesn't mean you shouldn't start when you have no issues, because that is absolutely the best time to make any plans. And then the other thing you need to understand is just because your friend has a plan doesn't mean you would do the same plan. There are a lot of similarities in asset protection plans, but each person has to be taken with their own assets, with their own liabilities, with their own situation. Don't expect that your neighbor's plan is going to be your plan. So don't try to copy them because you may be in a completely different situation. Also with the understanding that they may have things that they haven't told you about. So you don't actually always have the same assets as somebody else. Okay, let's go over a quick 5 killer mistakes to avoid. Number 1, asset protection is not about hiding. It doesn't mean you can't get any privacy, but it's not about hiding your assets. So the minute you come in and you say, I want to hide something, we're going to tell you, sorry, we can't help you. However, there are jurisdictions that can be used, and there are ways to do things so that you're not outwardly visible to the outside world. Of course, the IRS is going to know everything you're doing. Your CPA will know everything. So whatever you do, you need to be fully comfortable that what you're doing is going to be okay with the IRS and okay with the government, because, again, it's not about hiding. We can create some pitfalls for creditors when they're trying to find you, but you're not hiding it from anybody who's really important. Titling assets to straws. So this would be if you say, hey, I want the benefit of something. I want to pay for it, but I don't want it to ever be in my name. So then you go find a third party, usually a friend or a family member, and you say, hey, I'm just going to put this in your name, but we both know, wink, wink, it's really mine. That does not work. When you try that, what happens is that you're not thinking about a couple of things. Number 1, what happens if you and your friend or family member get in a fight? Well, they already own the asset, and you can go sue them and try to get it back. But, the courts are probably not going to be too sympathetic to you, because then why didn't you own it in the first place? The next thing you need to think about is, well, what happens if that person who's doing you this great favor gets sued? Somebody gets a judgment against them. Well, guess what? On paper, this is their asset. The judgment creditor can come take it. You don't want to have to try to unravel that and get involved in that lawsuit. People do the same thing when they try to put things in their spouse's name. Same concerns. A, what happens if your spouse gets sued? Then your spouse can lose the asset. And B, well, what happens if you get a divorce? Well, it's great for your spouse because they've already got everything in their name. So it's going to make the divorce a lot easier for them because it's already in their name. And lastly, I'm going to take two things together, the fraudulent transfers and the breaking laws. The thing to understand is the majority of the time a fraudulent transfer is a civil issue. It is not a criminal issue. It's basically where a person would transfer assets out of their name with the intent to not pay a creditor. Generally, again, it's a civil issue, and your creditor can come back and say, hey, we should have been paid that money. You shouldn't have transferred it out of your name. That's a fraudulent transfer. Judge, can you just reel that back in and so we can get paid? That's very different than breaking laws. Breaking laws would be, are you doing anything criminal? Are you violating a law that says that you can't transfer something to the detriment of others? You want to be very careful that whatever you're doing on your asset protection plan, you're not breaking laws. The best way to do everything is to do it proactively, legally, and ethically, and still have a good plan in place, because you can absolutely do that as long as you're doing it in the correct way. First thing we're going to start with is we'll start a little bit of regular partnerships, and then we'll segue more into the limited partnerships, limited liability partnerships, and the triple LPs. A partnership is basically a relationship between two or more individuals or entities where they decide to do something together. The general concept in a partnership is all parties are equal, which means they're equal in profit, equal in liability, unless the partnership agreement says otherwise. But the general concept is everyone in a partnership, in a regular partnership, shares equally in both the good and the bad. So if I decide to go into a business with someone and form a regular partnership and the business gets sued, well, each of me and my partner, we're both going to get sued, and we're both going to bear whatever the liability is, and it is personal liability at that point. We're also going to reap the profits. If we sell the partnership, we get the profits. If we, make money in the partnership, we reap the profits. So there's good and then there's bad. That's the presumption whenever there's any sort of agreement of partnership, or even if you don't have a written agreement and people go into business together. The general presumption is that you have a regular partnership. For our purposes, let's call that a general partnership. And that way we can associate the general partner with liability. So again, just a regular business, go into it with somebody else. It's what we call a general partnership. Everyone bears the liabilities and everyone reaps the reward. There's also what's called a limited partnership. And limited partnerships have been around for a very long time. And limited partnerships essentially say there's a general partner, at least one, and there's at least one limited partner. In this situation, the general partner has the full right to manage the partnership and also has unlimited personal liability for any partnership debts. So what does that mean? That means if whatever this business is, it's operating as a limited partnership and the business gets sued, then the partnership itself, all assets of the partnership are subject to the debts, and the general partner can also be personally liable if there's any money still owed after payment of the partnership assets. So with great power comes great responsibility, and that's the general liability that's involved there. Anyone who's a limited partner in this type of situation has no liability up over and above whatever they've invested in the partnership. So therefore, they might not have their partnership interest might not be very valuable after the partnership gets sued, but the creditors can come after the limited partner personally. Let me go over a couple of little nuances here. Let's put 100% on the table. So the partnership itself is 100%. In a regular situation, let's say it was a corporation. In a corporation, the ones who own the majority of the corporation, they're the ones who control. So if you more than 51% of the corporation, those people control. They choose the board, the people who run the corporation. In a limited partnership, the general partner doesn't need to have any more than one tiny little fraction of interest in a limited partnership in order to control the partnership. So the general partner can have 0.0001 as a general partnership interest, and they're in complete control of the partnership. They have, as we said, they bear the liability personally, unlimited, and they have full control. The limited partners can own 99.999% collectively. They have absolutely no management authority and therefore no control, and they have no personal liability. So, when you set something like this up, obviously you have to structure who's going to be the general partner, who's going to be the limited partner. There's ways to set it up where we can relieve the general partner of some of the liability, or at least the general partner always bears the liability, but we're able to insulate the individuals who would ordinarily be general partners and put them into, let's say, an LLC, where they can own the LLC can control as the general partner, but the individual members of the LLC would not have personal liability. So there's definitely a way to structure it so that the general partner in a limited partnership is relieved of the majority of the liability. The limited partnership interests are subject to what we call a charging order in many jurisdictions. Some jurisdictions have other methodology where a creditor can come after a limited partnership interest, but in general, what's special about limited partnerships is they have what's called a charging order protection. What a charging order is that in a limited partnership, limited partners and general partners are subject to distributions from the partnership. That's how you get money out of it. If you have a creditor and a creditor gets a charging order against you because now you have a judgment against you personally for something, the creditor can get a charging order against your limited partnership distributions. They can't take your limited partnership interest. They can't control it. They can't even inspect the books of it. All they can get is if you were to get a distribution, the creditor can get it instead of you. So in jurisdictions where they have that as an exclusive remedy, that's a really wonderful tool because you can have a limited partnership interest. It can continue to grow in value. It can even accumulate distributions depending on the agreement and depending on the jurisdiction. And your creditor would really just kind of stand there with their hands open but not receive anything. So it's actually a wonderful tool for asset protection. The critical element of the partnership, anyone can set up the limited partnership, but what it really comes down to is the agreement. What does the limited partnership agreement say? And the limited partnership agreement needs to address the general partner. How do you choose a general partner? It gives the general partner full and absolute discretion regarding distribution. So, if there are creditors involved on a limited partner's interest, the general partner can withhold distributions, which is a great way of not paying off the creditor. It'll prohibit transfers of the partnership interests without consent of the general partner or sometimes the majority of all partners. That's very helpful for somebody who wants to transfer out their interest against the interests of the other partners. And then the creditors of the limited partner, depending on the jurisdiction, will only be an assignee of that interest. They won't even get to partake in anything other than potentially the distributions from the partnership. There's many other clauses that need to go in these agreements, and it all is going to depend on what jurisdiction you're using for the partnership. And a lot of it also depends on who is involved in the partnership, who are the limited partners, who's the general partner. But really it comes down to anything you want to put in that agreement that's not against the law can be put in that agreement so that you really put in the best clauses possible, the best asset protection, the best estate planning. clauses so that you maximize the use of the partnership. Again, this is a very big tool that's used nowadays for asset protection. It's used in conjunction with other types of entities, maybe LLCs, sometimes corporations, as we're going to talk about the double LP, the triple LP. What we like about the limited partnership is essentially if you transfer things in there, depending on who's transferring it, it's usually a tax-neutral event, meaning you're not going to pay any more taxes once it's in the limited partnership. You're not going to pay any less taxes. Yeah, now that you're creating a limited partnership, there will be an additional partnership return, but you're not really going to be, you're not going to be paying more in taxes. With that said, if you are transferring any interest to someone else, meaning you're gifting a partnership interest, that you have to keep in mind there, it might be gift tax consequence depending on what state you live in. Anything you put into the partnership, if it's a family-held partnership, is potentially reversible, meaning if you are in control of the general partner interest and you also have a limited partnership interest, then potentially you can remove assets from the limited partnership. Again, a lot of that is going to come down to what is in the agreement and what are you able to do under the agreement. But for the most part, once you put it in there, as long as you're still the owner for IRS tax purposes, ultimately you can get it back. The limited partnership is very easy to maintain. You have to pay your annual fees with whatever state you create the partnership in. You have to make sure you have a registered agent who's always on the partnership in the state that it's created in. So if you set it up in, let's say, Wyoming, you don't live in Wyoming, you have to get a corporate registered agent to be your registered agent. It's not very expensive. It's just important for the partnership. No entity can be maintained without an active registered agent in that state. You should be maintaining and doing minutes if possible for the limited partnership. It's not required, but it's not a bad idea to keep them up. If you're ever sued, it's important to produce as much paper as possible, so the more that you generate, the better it is. So I would suggest minutes, resolutions. If you ever open up a bank account for anything, you know that the bank will hand you a resolution anyway. That's just something that should go into your limited partnership binder. Things that might go into a limited partnership in terms of assets. We already went over that there's personal liability if a person is a general partner of a limited partnership. We also talked about that you can insulate that by having a limited liability company as a general partner, and you as an individual can own that limited liability company. But we always like to be extra cautious and say that a limited partnership should not directly own anything that might cause any sort of liability. So you wouldn't want to own a piece of real estate in a limited partnership, because if you own the real estate in the limited partnership and something happens on the real estate, somebody slips and falls, well, they're going to sue the owner, and the owner being the limited partnership, the general partner can bear the liability. So that's not the way we want to go. So we don't want to put real estate in there. You also don't want to put in something where you would end up having to be, or the limited partnership would have to be the plaintiff or defendant in the lawsuit. So let's say there was a mortgage, and the limited partnership or the mortgage holder, they were the bank. It's probably a good idea not to have the mortgage owned directly by the limited partnership. Maybe have it owned by an LLC that's owned by the limited partnership. The reason we say that is because let's say the bank has to foreclose and the bank is a limited partnership. Well, they're going to foreclose. They're going to go to court under the name of the limited partnership, and let's say the borrower decides to sue them back. Well, now you've got a limited partnership open to potential liabilities, And that's not. And if you transferred the majority of your assets into that limited partnership, everything is at risk. So we really don't want to put anything in there where there would be a direct liability. With that said, you can put in cash, you can put in investments, you can put in accounts receivables, you can even put in shares of a C corporation, and you can put in membership interest in a limited liability company or other partnerships. So there are definitely a lot of uses for the limited partnership, but we always have to evaluate what can be owned directly and what needs some sort of entity to own it, which would be owned by the limited partnership. When you have a limited partnership, the creditor of either the limited partner or the general partner can't seize the partnership assets. The only one who can seize the partnership assets is if there is a direct judgment against the partnership itself. So if I'm a limited partner and I have a car accident and my insurance doesn't cover everything from the car accident, guy sues me, gets a judgment against me. He can come after anything I own personally. But if I have a limited partnership interest, he can come after the charging order or even foreclose on the partnership interest, but he generally cannot seize the partnership itself or take control of it. In jurisdictions where you can foreclose on the partnership interest, it becomes a little more tricky, but for the most part, the charging order is what they're going to get against distributions. So you have to be obviously wary of what jurisdiction you set things up so that you are basically protected under the best laws. But know your individual states as well, meaning the individual state you live in, because there are limited protections depending on what state you live in. The charging order, as we talked about before, gives the creditor only the right to claim the distributions that are payable to the limited partner. That means just because there's a potential distribution, if the general partner is able to withhold that distribution, then the creditor isn't going to get anything. And the creditor cannot force a distribution in most jurisdictions. So it's all going to come down to the general partner making the decision as to who gets a distribution. And if the general partner doesn't issue a distribution, then your creditor just sits there and gets nothing. Taxation. The partnership assets, as I said, you're going to file a partnership tax return for the partnership. There's a potential, and this is used with estate planning aspect, not just the asset protection. There's a potential to get a discount in the valuation of a partnership interest. Essentially, the way that works is, let's say you have a partnership that has $10 million in it. If you were to gift a limited partnership interest in that partnership to a family member, let's say you gifted it to your child, and you gifted a 5% limited partnership interest in that $10 million limited partnership to your child. Because your child is a limited partner and not the general partner, what will happen is when you file your gift tax return, and yes, you'll have to file a gift tax return in order to do this, you're going to tell the IRS, hey, it's a limited partnership interest. They don't control. They can't sell their interest. They're very limited in the scope of what this interest is. So we're not going to say that it's worth $50,000. We're going to say it's worth 20, 30% less because they should be entitled to a discount because there's no way that they can sell it. All they've got is this interest that's controlled by somebody else. Cash usually gets the least amount of discount, but depending on the assets in it, I've seen aggressive CPAs go to 40% or more. Again, this all comes down to how your CPA submits everything and what they can justify in terms of a discount. But if it's a limited partnership interest, you can really get a very good discount, and it's a great way of reducing the size of an estate and maximizing the amount of gifting that you could make. Everybody has right now, $5.45 million exemption from estate taxes and taxes. That's all they've got. seems like a very large number, but if your estate is much, much higher than that, by using the limited partnership discount, you can give away a significant amount more and reduce the potential for estate taxes when you die. Next thing I want to cover is double LPs and triple LPs. And essentially those are a limited liability partnership, which works a little bit different than a limited partnership. The limited liability partnership is more like a general partnership, except that each partner is not liable for the other's actions. They use this more for professional organizations like CPAs, attorneys, things like that. That way, if let's say a law office is a double LP and you've got 8 partners, then if one of them does something wrong, then the other ones are not going to be liable for the other one's actions. So this is used more like, for professional organizations. Let's call that a hybrid of the corporation and the limited partnership. So they'll bear personal liability for some things, but they're not going to bear personal liability for actions of one of the other partners. There's also what's called an RLLP. Some jurisdictions have what's called a registered limited liability partnership. It's also for professional organizations. Like in California, they don't have an option for a limited liability company or an LLC to own a legal practice, medical practice, architectural practice, but you can have the registered limited liability partnership. And then the other thing we have is the triple LP, the limited liability limited partnership. I think it's very confusing when you start trying to remember what people have, but this is a much newer entity that's out there. It's like a limited partnership. There's one general partner, but the general partner is not liable for any of the other general partners' actions. It's a hybrid, really, of the double LP and the limited partnership. The difference between the triple LP and the limited partnership is the liability aspect. In the limited partnership, we said the general partner bears all liability for all debts and obligations of the limited partnership. And in the triple LP, as we said, it's basically a way of insulating all general partner liability. For the triple LP, it requires what's called an election. You have to make an election under state law. Understand, not every state allows the triple LP, so it's not necessarily a valid type of entity in every state. States like Delaware have it. In other states, if you don't make an election, it doesn't work. So let's say Florida has the triple LP. If you don't make a proper election, then it's not counted. It's treated as another type of entity. It's relatively new. You've got states, let's see, I have a list of the states I'm going to pull up right here. Arkansas, Arizona, Colorado, Delaware, Florida, Georgia, Maryland, Nevada, Texas, and Kentucky. They all have statutes on it. You can convert an existing limited partnership into a triple LP. They're most common in real estate because, as we said, we never want real estate owned by a limited partnership because of the general partner liability. So in this particular type of entity with a triple LP, you can own the real estate because you're getting rid of the general partner liability. Okay, first question we had is, what is the most common way to protect a home or residence? With regard to what we were talking about today, you would not put a home or residence in a limited partnership. That's something you might consider doing in a limited liability company, although usually you want to keep that in your own name or maybe in a revocable trust. I think we had a webinar once on homestead. It depends on your state, what the homestead laws are. The thing we don't like to do with real estate, especially with a primary residence, is we don't like to mess with the tax laws. So if you put your residence into some sort of entity, you can potentially be getting rid of your capital gains exemption when you go and sell the house. Maybe you're messing with the interest deductions if you have a mortgage. So if anybody has a question similar to that, please give us a call and see what we can help you with. And again, it'll really depend upon your state. The next question I'm going to answer is, what occurs regarding an interest in a limited partnership upon death? Can it be bequeathed in a will? So the answer is absolutely. The limited partnership is just like any other asset. It's just like if you have shares in a corporation. Upon your death, it passes to your heirs. If you have a will and no trust, then it'll pass through probate, and the limited partner becomes, we have to look at the limited partnership agreement to see who is actually able to inherit it. It may require that the limited partnership itself buys it back from the estate. Again, we look to the agreement when we do that, but it most definitely is an asset that you own at your death. We talked about it getting some potential tax discounting. It's not just gifting the partnership at your death. If you die with a limited partnership interest, your estate would potentially get a discount on that interest for estate tax purposes. So if you have a trust, it can pass through your trust. If it could be owned by a trust directly, that's probably the best way to do it so that it works for both asset protection and estate planning. That's all for today. I want to thank everybody for participating. As I'm sure you're aware, we have a weekly newsletter if you're not already subscribing. We do webinars twice a month, one on asset protection, one on estate planning. I believe the estate planning one is next Wednesday. If you're interested in a complimentary preliminary consultation on your asset protection or estate planning needs, please feel free to give us a call. And if you have any questions regarding today's webinar, just email us at info@assetprotectionattorneys.com. Have a great rest of the week. Thank you so much.